This week on the Writers Detective Bureau, investigating a murder of one of your own, filming props, and testimony dialogue. I'm Adam Richardson, and this is the Writers Detective Bureau. Welcome to episode number 90 of the Writers Detective Bureau, the podcast dedicated to helping authors and screenwriters write professional quality crime-related fiction. And this week, I'm answering your questions about who investigates the murder when the victim is a police officer of your own agency, as well as how to best secure realistic props for filming and tips for creating realistic testimony dialogue. Big thank yous go out to Gold Shield patrons Deborah Dunbar from DeborahDunbar.com, CC Jameson from CCJameson.com, Larry Keaton, Vicky Tharp of VickyTharp.com, Chris Ann, Larry Darter, Natalie Borelli, Craig Kingsman of CraigKingsman.com, Lynn Vitale, Marco Carocari of MarcoCarocari.com, Robert Mendenhall of RobertJMendenhall.com, and Terry Swan for their support, along with my Silver Cufflink and Coffee Club patrons. You can find links to all of the authors supporting this episode in the show notes at writersdetective.com/90. 100% of this month's Patreon money was donated to Masks for Docs to provide PPE to those on the front lines of the COVID-19 pandemic. If you have funds or PPE that you'd like to donate to doctors, nurses, or first responders, or you are a first responder or medical professional that's in need of PPE, go to masksfordocs.com to get connected right now. And to learn more about patronage through Patreon, go to writersdetective.com/Patreon. Patreon. This week's first question comes from Ryan Elder, and Ryan writes, "Thanks again for your advice before. I have an idea for a screenplay, and I was wondering if it was realistic or not. If a police officer is murdered, is the same police department he worked under allowed to investigate it? Or would a more impartial division, such as Internal Affairs or any other agency, come in and take over the case? The officer was killed while he was off duty, and there are clues to suggest it may be linked to a case he was part of investigating in the past. Would that make any difference as to whether or not an outside department would take the case? If an outside division would take over the case, is there any way the police department the victim worked under could be in on the loop or still part of it in any way? Thank you very much for any advice." Interesting question, Ryan. I've actually seen both, where the same agency that had an officer killed work the murder investigation, and I've also seen another agency handle the murder investigation on behalf of the victim's agency. But the latter has tended to be when the victim's agency is quite small. If the murder happens within the city limits of that police department's area of responsibility, then that is still their murder case. The conflict of interest concept might be something the defendant, meaning the suspect in this murder case once he's captured, might be something the defendant's attorney tries to argue at trial if the defense strategy is to allege that an overzealous detective bureau is framing his client. But to my knowledge, there's nothing that makes for a conflict of interest by having a police department investigate a murder in their city, even if it's one of their own that died. So by all means, write it as you see fit. You could plausibly write it so that another investigative unit within the department might take over the case, but if your victim was a detective within the homicide unit would still likely be the one working the case. You mentioned Internal Affairs in your question, and just real quick, the job of Internal Affairs is to investigate police wrongdoing. They aren't necessarily homicide investigators, but it is possible that there may be that homicide investigation expertise in IA if a former homicide detective is now working in Internal Affairs. Realistically, though, especially if the working theory is that the motive for killing the detective is tied to a case he was working, or worked in the past, then this detective's murder might really just be an expansion of that original case, as they may possibly involve the same players. But the full force of the entire police department would be brought in to work the case. This won't be a pair of detectives working on a homicide now. This is going to be the entire detective division, or divisions plural, working this case. You may have narcs and vice doing surveillance or putting out feelers through informants, and then all those suit and tie detectives, regardless of whether they're assigned to property crimes or sex crimes or whatever, will be pulled from their respective caseloads to do interviews and watch surveillance camera footage and staff a wire room listening to suspect phone calls, that kind of thing, whatever else needs to be done. So having worked big cases like this, the homicide unit is still remaining in charge and then farming out all those tasks or assignments to the other units that are involved in the case. But all of those were always given to us by the homicide unit. So I hope this helps, Ryan. Appreciate your question. Gabriel Porter asks, where could I find all the documentation that would go into a murder book for filming purposes? Additionally, how could I obtain a badge depicting the county or town's name? Is that impersonation? And then he went on to say, you don't have to include this part, but I'm going to include it anyway because it's great. He says, I just want to make my intentions clear. I just want to be able to print off similar documents and fill them out as my character would. I plan on trying to film what I have written, and I'm going for as realistic an approach as I can. Is that considered forgery? If so, are there other ways I could obtain the types of documents an investigator would have to fill out? Thank you so much. I love your podcast. Well, thank you so much, Gabriel. I really appreciate that, and thank you for the questions. For starters, let's get your concerns about getting into trouble out of the way. The crime of impersonation of a peace officer is a misdemeanor, and impersonation is wearing the badge or uniform, insignia, certificate, card, etc. of a peace officer with the intent to fraudulently induce the belief that he or she is a peace officer. Now, that's paraphrasing the law here in California, which is 538D of the California Penal Code. But down at the very bottom of this section, so 538D, parent E, parent 3, it reads, this subdivision shall not apply if the uniform is solely used as a prop for a motion picture, television, video production, or theatrical event, and prior written permission has been obtained from the identified law enforcement agency. So you should be good to go, Gabriel. Just get that prior written permission. In fact, it can't hurt to notify whichever agency you go to get your filming permits that you'll be filming actors in uniform, and definitely let them know if any prop firearms are going to be used for your filming as well. Now, if this is a student film or a short you want to film for YouTube, a filming permit is still likely going to be required if you're doing any kind of location shoots. So definitely check with your local government on filming rules. The last thing you want is the cops showing up because a neighbor hears yelling and guns being pointed and that kind of thing. Part of the film permit process is making local law enforcement aware of the film shoot, which comes in handy when you want to shut down a street for filming, especially. As for getting the badge, you may have to have a prop badge made. Some agencies like LAPD and Las Vegas Metro actually have a trademark on their badge images. So when you see a modern cop show filmed in LA or Vegas, the badges depicting those agencies are usually slightly different from the real ones. So kind of like using prop money when you're filming, no one except for the real cops are going to notice the slight difference. As for the murder books, especially to make a prop one, you can just Google image search police reports. Even look for PDFs of police reports in connection with real court cases. Many of the reports that have been entered in evidence and then have gone through the discovery process, meaning the police documents have been turned over to defense counsel, will turn up on the internet. You can then get a feel for what the reports look like and then make your own versions with the names and circumstances of your story. The only way this could be forgery is if you try to pass these documents off as being anything official for any kind of monetary gain, that kind of thing. So if you do print them off and only use them as a prop for filming, you should be okay. And it can't hurt to have some fine print in the margin or the footer that the camera won't necessarily focus on that disclaims the form as being official. Again, using that prop money analogy, rather than this note is legal tender on a real dollar bill, it says something like this note is for motion picture use only. You could do something similar in the reports that you come up with to create your murder book. The murder book is really just a repository of all the various police reports and interview transcripts, crime lab reports, autopsy reports, and then a running chronology of the investigation, basically a running list of who did what and when. So if you just plop forms that might pass for those things into a 3-ring binder, you pretty much have a murder book worthy of filming. Just write the case number on the outside of the binder for that final piece de resistance. Above all, just use common sense and follow all the filming guidelines for your local government, and you should be good to go. Amy Abrigo writes, I'm writing about crime fiction called Do You Trust Me? And I realized I will have to write down what happened inside the courtroom. What possible examination and cross-examination questions about rape and murder may lawyers ask a suspect and or witness? Thank you. Ooh, this is a very big question with pretty much unlimited answers, which is actually a good thing for you, Amy, because it means you have a ton of leeway with your dialogue. The key things to understand, which I actually briefly addressed in the last episode of this podcast where I talked about courthouse waiting rooms, is that the prosecution goes first in a criminal trial. The prosecutor, which may be a deputy district attorney, a deputy attorney general, a state's attorney, or what have you, their title is going to depend on where you set your story and which prosecuting attorney's office is bringing the case to trial. But anyway, that prosecutor's job is to lay out the story of what allegedly happened to a jury. So let me back up a second. The trial will usually start with the prosecutor and the defense attorney making an opening statement to the jury, each of them explaining to the jury what they are about to hear, and then briefly what evidence they can expect to be presented during the trial. These statements are not made under oath. They're just attorneys addressing the jury. Then the prosecutor begins laying out their case, which means they need to try to prove whatever crime has been alleged. And this is where your questions come into play. The prosecutor has to prove to the jury that the defendant committed the crime, and to prove it, the evidence must prove the defendant's guilt beyond a reasonable doubt. The way the prosecutor goes about this is by calling witnesses to testify and then asking those witnesses questions. The witnesses, as you are undoubtedly aware, swear under penalty of perjury that what they say on the witness stand is the truth. What that really means is that if the witness lies, they can be prosecuted for it. Lying while under oath on the witness stand is the crime of perjury. So if you were the prosecutor, who would you call as a witness, and what questions would you ask them? You'd probably call to the stand the person that called the police to report the crime and the police officer that responded to the call. And you'd probably call the detective that responded or was assigned to take over the investigation. You might call the nurse or doctor that examined the victim. You'd call pretty much anyone and everyone that can offer insight into what happened, what they saw, or what they did. Where it gets tricky is when a witness wants to testify not about what they themselves saw or did, but what they heard from someone else. And that is called hearsay. And for the most part, that is not admissible as evidence. And that's the kind of thing where the defense attorney will object to an answer from a witness. And by objecting, they're essentially looking to the judge to make a ruling on whether it's admissible or not. Kind of like looking to a referee in a ball game to see if the ball went out of bounds or not. Here in the United States, we have a Fifth Amendment right to remain silent and not to be compelled to testify against ourselves. So the prosecutor can't call the defendant to the stand and force them to testify. Same thing goes for not calling the defendant's attorney to testify against his or her own client. That isn't to say that the defendant won't ever testify. It's just that the decision to testify comes down to the defendant and her defense attorney on whether that is a wise strategy. So even though the prosecution can't call the defendant as a witness, the defense attorney can. Now, anytime either side calls a witness, after that initial questioning of the witness is done, the other side gets to ask their own questions of the witness. This, as Amy mentioned in her question is called cross-examination. And I'm sure you've heard that term before. So when the prosecution calls the detective and the detective answers all of the prosecutor's questions, then the defense attorney gets to ask the detective questions as well. Once the prosecution has finished calling witnesses and introducing evidence, the prosecution will rest. Then it's the defense attorney's turn to call their own witnesses to either disprove what was presented by the prosecutor or introduce exculpatory evidence, meaning evidence that proves the defendant is not guilty of the crime, or simply to introduce testimony or evidence that plants the seed of reasonable doubt in the minds of the jurors. There are so many ways to accomplish any of those things that it's hard for me to give a complete list of examples. But if the defense attorney was able to introduce evidence that the defendant was actually fearing for her life and defending herself, that may sway the jury into believing it was a justifiable homicide rather than a premeditated murder, essentially giving a self-defense defense. If the defense is able to show that the defendant couldn't have committed the crime because evidence proves she was elsewhere when the murder happened, or perhaps the DNA match on the murder weapon was left by the defendant's identical twin, a twin the prosecution didn't even know existed, that might be enough reasonable doubt for the jury not to be sure that the defendant was the one responsible instead of the twin. So then, once the defense is done presenting all of their rebuttal evidence, it gets turned over to the jury to decide the defendant's fate. The jurors will go into a jury deliberation room, which is usually a room immediately adjacent to the courtroom, and only the jurors are allowed in there for deliberations. The only exception usually being the bailiff if the jury needs to send a note to the judge. Then the jurors stay in that room until they come to a verdict. I mean, they do get to leave at the end of the day and come back the following day if it continues on, but you get what I mean. And when that happens, when the jury deliberations go on for days, they don't just come and go from the jury deliberation room. They're actually seated in the jury box in the courtroom, and then the judge addresses the jury at the end of each day. Oh, and real quick, going back to the cross-examination thing, remember when I said a defendant's decision to testify is a strategy thing for the defense team to decide on whether it's wise or not? If you, the defendant, decide to testify and your defense attorney asks all the right questions that lets you explain your side of the story, you've essentially waived your Fifth Amendment right to self-incrimination, and the prosecutor gets to cross-examine you. And remember, you're testifying under oath, so perjury rules apply on top of everything else you're facing if convicted. Not that a little perjury charge will mean much if you're convicted of a rape or a murder, but it might be enough when it comes time for sentencing that being seen as a bold-faced liar on the witness stand might mean a harsher sentence than if you didn't testify at all, assuming you're convicted. So back to your original question, Amy. My suggestion for you for learning what kind of questioning and dialogue sounds realistic is to go to your local courthouse and sit in on a trial. Here in the United States, most criminal trials are open to the public. In fact, I'd suggest sitting in on a preliminary hearing in addition to a criminal trial or instead of a criminal trial, because they tend to go faster than a full-on trial, and you'll hear more of the case in a shorter amount of time, and you'll hear some great examples of witness testimony. If you aren't able to make it to a courthouse to hear testimony yourself, check out Court TV. I'm pretty sure their website is courttv.com, but check out their on-demand section to watch real court cases and hear real testimony. Binge a few trials and you will get a sense of how questioning really works and how you can create some realistic dialogue for your own story. Thank you so much for the question, Amy, and I hope this helps. Thank you so much for listening this week. This show is powered by your questions, so send them to me by going to writersdetective.com/podcast. Thanks again for listening. Stay inside, stay healthy, have a great week, and write well.